Opposed by Mr. Learned counsel for the petitioner. This matter stands adjourned to be adjourned for the day.
Yes, your lordship.
Okay.
Much obliged.
May I please, Lordship? My Lord, I beg to mention item number 17 on behalf of Moa Imchen, Senior Government Advocate, my Lord. My Lord, I'm informed that pleading is complete, so let the matter be listed after 1 week.
Okay. Mr. Your name?
Tipap Home,
Learned counsel appearing on behalf of Mr.
Moa Imchen.
Learned counsel for the petitioner.
No, for the State Council.
No, learned counsel. No, learned government advocate. This matter stands adjourned to be listed after
1 week, my Lord.
1 week. And he also submits that since pleading is completed, the matter may be listed for admission hearing.
Yes, my Lord.
Okay. Fair allowed. This is at least the matter for admission hearing.
My Lord, again, I beg to mention item number 18 on behalf of Moa Imchen, my Lord.
Same order.
To
Here,
file
pleading
counter.
completed?
Here, to file counter 2 weeks, maybe under my Lord.
Okay. He pays for 2 weeks time to file counter affidavit. Fair allowed. This is at least the matter after 2 weeks.
Similar prayer for item number 21, man. To file counter.
Okay.
Much obliged.
May it please Lordship, I beg to mention item 4. This case, the pleadings are complete. I pray the matter be listed for hearing.
You are for the petitioner,
I'm for the petitioner, my lord.
Mr. Perkins Sabon.
Yes, my lord, I'm Pakunital.
Learned counsel for the petitioner submits that in this matter pleading is completed and as such the same may be listed for admission
Yes, for after 2 weeks.
after 2 weeks. Fair allowed.
Applied, my lord.
May it please your lordship. Lordship, I beg to mention item 14 for the state respondents. We have received the instructions. I pray for 3 weeks to file an affidavit in opposition, your lordship.
Mr. Your name?
M. Longcomer.
Learned counsel for the state respondent.
Yes, your lordship.
Submits that he has received the instruction and he may be granted 3 weeks time to file counter affidavit. Fair allowed. This is at least the matter after 3 weeks.
Much obliged.
Lordship, may I be allowed to mention item 2? Sorry, your lordship, item 10. On behalf of additional AG in Team Song. As is indisposed, I pray that the matter may be listed after 1 week.
Lordship, they have not informed me I'm ready for today's
Okay.
hearing.
Okay.
Then let the matter come up on 31st as a fixed item, Lordship.
31st.
Monday, yes, that is
Okay.
Monday.
Mr. So learned counsel appearing on behalf of I am some.
Title.
Team Song, yes, your lordship.
Hello.
Uh,
Pleading has been completed. Hello? No, sorry. Steps have been completed. Yes, so we will fix it for admission hearing. So when is Manish Chaudhary is going?
Yes.
list this matter on 31st
No,
as
31st.
a fixed item.
Lordship, can it be on Tuesday, my lord? Tuesday, I have other hearing matters also, Lordship. Like the next day, Monday, that's obliged.
Okay.
Obliged, Lordship.
Yeah, please, your lordship. Your lordship, I beg to mention item number 28. Kindly allow 2 weeks.
20?
28.
28.
Yes, your lordship. Kindly allow 2 weeks to file reply to the additional affidavit filed by the state respondent.
You are for the petitioner.
Yes, your lordship.
Miss, your name, please.
Renmoni.
Learned counsel for the petitioner submits that the respondent authorities have filed their counter affidavit and she may be granted 2 weeks time to file reply
Yes,
to
your
the counter affidavit filed by the state respondent. Fair allowed. This is at least the matter after 2 weeks.
much obliged. Lordship, I beg to mention item number 7. In this matter, we are yet to file reply. So kindly grant us 3 weeks time.
You are for the petitioner. You are for the petitioner.
Yes, your lordship.
Miss, your name.
Rubika.
Learned counsel.
See the latest course, please.
Learned counsel for the petitioner with consent from the other side. Price for listing the matter after 2 weeks so as to enable her to file reply to the counter affidavit.
Lordship, I beg your pardon. I think there is a slight change in the cause list. The cause list that I have is item number 7.
It is a rate petition number 119.
Read petition 119 of 2025.
Yes, it is all right. Okay.
Yes, much obliged.
May please, Lordship, Lordship, I beg to mention item number 19 and 20. Lordship, can you grant me 3 weeks time to file objection in the IA in item number 19 and 20?
Okay, Ms. V. Sukari, learned additional advocate general. For the state respondent with consent from the other side, request for listening the matter after 2 weeks.
3 weeks.
After 3 weeks, so as to enable her to file objection to the IA.
Yes,
I. They are allowed to list the matter after 2 weeks.
3 weeks,
3
Lordship.
weeks.
Lordship, I'm for the private respondent. We will,
Private respondent number.
in item 19, I'm for the private respondent number 9 and 20, private respondent number 8.
Okay,
We will be also filing our objection to the I.
okay. The learned counsel for the private respondent number 9 and 10 in item number 20.
8 in item number 20.
8 in item number 20. Also praise for granting her some time to file reply.
Objection.
Objection to file objection to the interlocutory application. Where allowed.
Much pleasure.
May please, Your Lordship, I beg to mention item number 18. And for the,
18, someone has mentioned the matter already.
There's an interim in that case, Lordship, for the.
Interim order.
Yes, yes.
Okay, interim order passed earlier. Item number 18 shall continue.
Lordship, if it can be fixed on 7th of September.
Okay, 7th of September.
obliged.
Lordship, I also beg to mention item 16. Here, I'm for the petitioner. I'll be filing my reply in the course of the day.
You are for the petitioner.
Yes,
Nice, so learned counsel for the petitioner. You want to file a reply,
yes, reply
the
to
counter
the,
affidavit. Submits that she may be granted. How much
Uh,
time
I'll be filing in the course of the day.
today?
Yes,
Submits that she will be filing the filing her reply to the counter affidavit filed by the state respondent during the course of the day. And press for listening the matter after
3 weeks.
3 weeks. Very allowed.
I also beg to mention item 27. Here, I'm for respondent number 7. I've taken the consent of the opposite party.
Nice, so learned counsel for the respondent number 7 with consent from the other side. Any objection?
Lordship, I have it be fixed on 8th of September.
8th of September.
Yes, my lord.
With consent from the other side, press for listening the matter on 7th, 8th of September. 8th of September. You want to file here,
No, pleadings are completed.
pleadings
Yeah, completed.
completed.
This is for hearing, yes.
Pleadings okay,
God
7.
bless you.
Oh, no, okay, 8 on 8.
Right.
May please, Your Lordship.
Hmm.
Lordship, I beg to mention hearing item 30 and 31, Lordship. I for the respondent number 4. Lordship, be gracious if this matter may come up after 2 weeks, Lordship.
Mr. Your name?
Week was our Lordship.
Learned counsel for the respondent number 4. With consent from the other side, press for listing the matter after
2 weeks, Lordship.
after 2 weeks. Any objection?
No, Lordship.
Fair allowed.
Interim may be extended, my lord.
Interim order passed earlier shall continue.
Much obliged.
Much obliged. May please, Lordship. Lordship, I beg to mention item 17. I am for the petitioner here, Lordship. Kindly allow me 1 week time to file my affidavit in reply.
No, somebody has already mentioned the matter.
Lordship, there is an interim, then, Lordship.
Okay, interim order passed earlier shall contain in item number 17.
Much obliged.
Your Lordship, I beg to mention item number 15. Here I'm appearing for respondent number 4. Your Lordship may kindly grant us 4 weeks' time to file our affidavit in opposition.
Okay.
Please, Lordship. My lord, this was filed in March. And till today, either central government, state, nor the private, but have not filed any affidavit. So now in my respectful submission, sufficient time have been granted to them. March, this is going to be September, August last.
Okay. How much time do you want?
4 weeks' time, Lord.
My lord, that's unreasonable.
We'll grant you 1 week time. You file it.
Your Lordship, actually, we are yet to obtain vital documents from the competent authority. Because of that, we are delayed.
You
If
forced
lordship,
them. Okay, 2 weeks.
my lord,
And
if,
this will be the last chance.
my lord, if lordship read earlier order 28th July, Union of India was directed to file affidavit within 1 week. Till now, even Union of India has no file. My lord, no problem. Now for 2 weeks taken.
Okay, heard Mr. Zo, learned senior counsel, assisted by
V Koza, my lord.
P. Koza, learned counsel for the petitioner, and also heard Mr. N.K. Lukham,
You come for and
learned counsel for the respondent number 4. Mr. Lukham, learned counsel for the respondent number 4. Price for listening on a price for granting him 4 weeks time to file counter affidavit, as he has not received any instruction. But Mr. Zo, learned counsel for the petitioner, has opposed the same. Accordingly, taking note of the submission of learned counsel for both the parties, last opportunity is afforded to the respondent number 4 to file the counter affidavit. Recessal is the matter. After 2 weeks on, we will fix a date.
Lordship may fix a date.
Suggested it.
Yes.
Suggested it.
This is today's one. Okay, it's complete. Can it be 15, 16, either of this?
15.
15?
15th of September?
Well,
Okay. It is being clarified that in the event of failing to file the counter affidavit, the court will proceed to hear the matter without the affidavit of the respondent number 4. Okay.
much of that.
May bless your Lordship. Lordship, I beg to mention item number 2, Lordship. Lordship, I may kindly be granted 2 weeks' time to file affidavit in reply.
You offer the petitioner.
Lordship,
Heard, Mr.
on behalf of Saint Yammer,
Your name.
Nagla M. Konyak.
Learned counsel appearing on behalf of Mr. Secretary, learned conducting counsel for the petitioner, and also heard Mr.
M. Longkumar, government.
Learned government advocate for the state respondent. Learned counsel for the petitioner submits that he may be granted 2 weeks time
Lordship,
to file a reply to the counter affidavit filed by the state respondent. Fair allowed, recessal is the matter after 2 weeks.
Lordship, there is an interim.
Interim order passed earlier shall continue. Okay.
Lordship, I also beg to mention item 6, Lordship. Lordship, this morning only we have received an affidavit filed by the respondent 7, Lordship. So 3 weeks' time may kindly be granted to file his
So
reply.
and so learned counsel appearing on behalf of Mr. Secretary submits that he has received a counter affidavit today morning and he may be granted 2 weeks
3
time.
weeks, 3 weeks,
3
Lordship.
weeks time to file a reply to the counter affidavit filed by the state respondent. Fair allowed. You are Mr. Longkumar, you are appearing for the state respondent.
Yes, Your Lordship.
Mr.
Okay.
Longkumar.
I'm
for
for
state-
private respondent.
You are
For private respondent.
private respondent number
7.
7.
Yes.
Your name?
James Newman.
Okay. Okay.
Lordship, there is an interim.
Interim order passed earlier shall continue.
Lordship, I also beg to mention item 12, Lordship.
You are for the petitioner.
Lordship.
Why?
Lordship,
Why?
let this matter may be listed after a week, Lordship.
Why?
Lordship, since a leading counsel will have some personal difficulties today, Lordship.
Who is the leading counsel?
Send the younger, Lordship.
Okay. Mr. Swenson, learned counsel appearing on behalf of Mr. Santi Iyengar, learned conducting counsel for the petitioner with consent from the other side. Rest for listing the matter after a week. Here alone, rest is list the matter. We'll fix it at
Yes, Lordship. First September, Lordship.
1st September.
Lordship.
Alright.
Obliged, Your Lordship.
Lordship, I also beg to mention hearing item number 32, Lordship. Hearing
30?
32.
30?
32.
32.
Lordship, this matter may become after 2 weeks, Lordship.
Okay. Mr. Swenson, learned counsel appearing on behalf of Mr. Santi Iyengar, learned counsel for the petitioner with consent from the other side, as well listing the matter after 2 weeks.
Lordship.
Here alone.
Obliged, Lordship.
Pleasure. May it please the Lordship. Lordship, may I mention item number 25, Lordship. Lordship, here I have instruction to appear on behalf of R5. Can you allow me 3 weeks time to file my Vagalatama and also affidavit in opposition?
Respondent number 5.
Five,
Five.
Lordship.
Who is for the petitioner here?
Item. Lordship, it appears petition. Advocate is not present.
Okay. Done appears for the petitioner on call. How about Mr.
James,
Learned counsel for the respondent number 5 present, and he pays for listing the matter after
3 weeks, Lordship.
3 weeks.
Lordship.
So as to enable him to file his Ukalandama. They are allowed. This is at least the matter.
23.
Lordship, I'm appealing for the petitioner.
After 3 weeks.
Lordship.
After 3 weeks. Is your name?
Mapini.
Learned counsel for the petitioner? For the petitioner?
Yes, for the petitioner.
Petitioner present. Okay.
Much obliged.
Members, my lord. Lord, I beg to mention item number 5. Yeah, I'm for the petitioner. I've received the affidavits of the respondents. I'm yet to file my reply. Or should maybe gracious enough to grant me 3 weeks time to file my reply, my lord.
Mr. Kosiko Patel, learned counsel for the petitioner with consent from the other side, press for listing the matter after
3 weeks, my lord.
after 3 weeks, so as to enable him to file a reply to the counter affidavit filed by the state respondent. Pair allowed, this is at least the matter after 3 weeks.
My lord. Bless my lord.
Yeah, please, my lord. My lord, I would like to mention item number 22. My lord, I'm for the respondent number 2.
Okay.
I'm yet to receive instructions, so will kindly grant me 2 weeks time to file my affidavit in reply.
Heard Miss,
Moreno.
learned counsel for the petitioner. And also heard Mr.
Authorised.
Learned counsel for the respondent number 2. Learned counsel for the respondent number 2 submits that he may be granted 2 weeks time as he has not received any instruction till date. Where allowed, recess at least the matter after 2 weeks.
Obliged, my lord. Thank you.
For motion, item number 1.
May I plead your lordship?
Yes.
Lordship, this instant matter pertains for the promotion of the petitioners as PA to DC under the district of Mon, Nagaland. Your lordship, here in the instant matter, I have been appointed as Dobasis grade 2 under the establishment of Deputy Commissioner Mon. Accordingly, your lordship, after my appointment, after serving 25 years in the concerned establishment, I have been promoted as special grade DB post under the establishment of Deputy Commissioner Mon. Then your lordship, in the meantime, as per the seniority list, one incumbent by the name Ongpang Konyak and Bumak Konyak, they both got retired in the year 2022 and 2024 respectively. Accordingly, your lordship, two posts were vacated because of the retirement of the two incumbent. So accordingly, the concerned department, they have initiated the proceeding for the promotion of the incumbent who are below the seniority list. So your lordship, here, the respondent number 6, who is EP Hamchung, as per seniority list, he is the most senior most incumbent in the department. So accordingly, department sent his recommendation for promotion to PA to DC, but since 20 years of qualifying service, he was not completed. So accordingly, higher authority, they have rejected that if they promote him, then it will amount to violation of Dobasi Service Rules 1970, as well as Office Memorandum dated 29/8/2019, which says that for a post to PA to DC, minimum qualifying service of 20 years is mandatory. So accordingly, his recommendation was rejected. So as for seniority list, your lordship, now I am the most senior most. Now since there are two post vacancies, so accordingly,
what is your qualifying years of service?
I have been appointed in the year 1997. Now it's more than 20 years. My qualifying service has already been qualified. But since as per seniority list, I am not above that respondent number 6, E.H. Hampung. So department said that since because of seniority list, I cannot be promoted. And your lordship, in the meantime,
Mr. Suren, you have filed one representation to the deputy commissioner.
Lordship.
What happened to that representation?
In that representation, the deputy commissioner has stated that, clarified that whatever decisions were taken, that were all as per the law and as per the direction of the higher authority. But in the meantime, my representation was not considered. And here, your lordship, we have also approached
Not
respondent number 6.
considered means, is it pending till date?
No. It has already been considered. Deputy commissioner has already clarified that in earlier, whatever decisions were taken were all as per the law and as per the direction of the higher authority. So here, lordship, that senior most incumbent, respondent number 6, he has also issued one NOC stating that if I have been given promoted, he does not have any objection. So because of that, now I'm approaching before this honorable court that this honorable court's interference is required, your lordship.
So you have been recommended by two departmental promotion committee.
Lordship.
For being appointed as political assistant.
Lordship.
Oh,
But
who is
since
the DPC? Who is in the DPC? Whether deputy commissioner was a member of the DPC?
Lordship, yes, lordship. He was also a part of the DPC.
Then how he recommend your name?
That is what, lordship, because as far as I know, the procedure of DPC is that it is by the majority. So since there were vacancies, so that is how my names were recommended in the DPC. And accordingly, the DC has also forwarded my recommendation, but the higher authority says that since I am not in the seniority list, and it will amount to violation of this seniority. So that is how my representation was not considered.
Okay. Yes. If the posts are vacant, if the departmental promotion committee has recommended the name of the petitioners, and the private respondent number 6, if he had given the no objection certificate, where is the bar in promoting the present petitioners?
Here is mentioning of service rules.
Yes.
So maybe at this stage, notice maybe issued, and let me also obtain some instructions from the department so that get a more clear
The
picture.
service rule means service rule. 20 years of continuous service.
Yes. Things precision.
So the question is how the respondent number 6 becomes senior to the present petitioners? if he has not completed 20 years of service,
Yes.
whereas the present petitioners have completed 20 years of service. On what basis his seniority was fixed above the present petitioners?
The Lordship, kindly allow me to obtain instruction in this regard. Possibly he was appointed to a higher grade. The possibility is there. Possibly.
Respondent number 6.
Yes, yes.
Okay. Heard Mr. P. Surin, learned counsel for the petitioner, and also heard Mr. Angami, learned government advocate for the state respondent number
1 to 5, Lordship.
1 to 5. 1 to 5. This petition under Article 226 of the Constitution of India, the petitioners, two petitioners, namely Kami Konyak and Y. Yapong Konyak, write for issuing direction to the respondent authorities to promote them to the post of PA to DC MON under the establishment of the Deputy Commissioner MON against the 3 existing posts under the said establishment of the Deputy Commissioner MON. And stroke or to direct the respondents to rearrange the seniority list of Dubasis under the establishment of Deputy Commissioner MON as per date of appointment of the incumbents under the establishment of the Deputy Commissioner MON. So Surin, learned counsel for the petitioners submits that the petitioners have been serving as Dubasis in the office of the Deputy Commissioner MON on account of 2 vacancies arose on retirement of 1. What is the name of the person or persons who have retired?
Lordship, paragraph 4, Sri Hangpong Konyak, page 10, paragraph 4, Lordship.
Hampong Konyak and Sri M. Bamang Konyak. The name of the petitioners were recommended twice by the Departmental Promotion Committee, but they have not been promoted. Now, despite recommendation by the Departmental Promotion Committee, they were not appointed to the post. In spite of the no objection certificate given by E.P. Hamsang, who is senior to them, and who failed to satisfy the requirement of 20 years of continuous service for being promoted to the political assistant. And being aggrieved, the petitioners have filed one representation to the Deputy Commissioner MON, but the same failed to yield any result. And being aggrieved, the petitioners approached this court by filing the present petition seeking the relief as aforesaid. Let notice be issued to the respondents, returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 to 5. Since Mr. Angami entered appearance and received notice, however, extra requisite copy of the petition will be furnished to him during the course of the day. Step upon respondent number 6 be taken by speed post and also by usual process within a week from today. List the matter after 4 weeks. In the meantime, Mr. Angami, learned government advocate, shall obtain necessary instruction in this regard.
For orders, item number 23.
Lordship, I am appearing on behalf of respondent 2 to 4.
But you are not visible.
Lordship, hello?
Yes.
Lordship, am I audible?
You are audible but not visible.
Lordship,
Yes.
Lordship, I'm appearing on behalf of respondent 2 to 4, Department of Income Tax. On behalf of Senior Standing Counsel of Income Tax, Mr. S. Chetia.
Okay.
Lordship, we are praying for 4 weeks' time to file affidavit, Lordship.
Heard, Mr.
Philip Lorin.
Learned counsel for the petitioner, and also heard, Miss. Your name, please.
A. Pradhan,
Learned counsel appearing on behalf of Mr.
S. Chetia.
Learned counsel for the respondent number 224. 224. Learned counsel appearing on behalf of respondent number 224. Praise for granting 2 weeks time.
Lordship, 4 weeks' time may be granted, Lordship.
4 weeks time to file counter affidavit in this matter. They are allowed to recessize the matter after 4 weeks.
Much obliged, Lordship.
Highly obliged, Lordship.
Item number 24.
May it please your lordship. Lordship, as per office order dated 5/8/2026, steps upon respondent number 3 and 4 has been completed, my lord.
You are for the
And for the petitioner, my lord.
Mr. Fote, you are for respondent number?
No, I'm for the petitioner.
Oh, you are for
I'm the
the
legal counsel.
Okay. Whose name is to be recorded? Yours or his?
Since Mr. Sharma is submitting, I
Okay.
think his name be recorded.
Heard, Mr. Sorma.
My
Learned
lord,
to
a
the
small submission, my lord, before Lord's passes order. My lord, in similar cases here in Gauhati, after seeing the records, the writ petitions have been allowed because without following the due process of law and because it's a violation of natural justice, the debarment notices has been issued. In fact, my lord, the order is there in the file. On the last occasion, the learned single judge was pleased to pass an interim order to the extent that this department order will not be effective to the other parts of the country. So, my lord, this case may be disposed of in the next day if there is a show on record, because the show cause notice which they have issued to us, that is also is not in our name, and they debarred us. And my lord would be aware of the judgments of the Supreme Court, my lord, that when a department is ordered, then you at least have to give them a hearing. So that is this entire case is about, my lord. My lord, I would like to take to the order line, my lord, at page on 31/7/2026.
Okay, on next date we will consider.
Yes, my lord. My lord, may produce the records, my lord.
Who is for the state? Who is for the respondents?
My lord, the additional AG has been appearing, my lord. AG Mr. Imti.
Yes. He's indisposed today, your lordship.
Pardon?
He's indisposed today, your
Okay.
lordship. Yes.
Heard, Mr. Sorma, learned counsel for the petitioner, and Mr. Learned counsel appearing on behalf of Mr.
Additional AG Imti Song.
Imti Song.
Yes, your lordship.
Imti Song. Mr. Sorma, praise for listing the matter after
On 7th, my lord.
on 7th. On 7th. Fair allowed. On next date, the learned additional AG shall produce the relevant file before the court. And on that day, an endeavor will be made to finally hear and dispose of the matter.
My lord, interim order may continue.
Interim order pass early shall come.
Most of them. My lord, there are two petitioners, so my learned friend appearing there can be recorded for petitioner number 2, if Lord pleases.
Okay. Mr. 44 respondent number, no, petitioner number.
Much obliged, my lord.
Please, my lord.
Right, your lord.
Item number 26.
May it please, my lord.
Yes.
Lordship, on 14/8/2026, today has been fixed for interim order. Lordship, there is a blatant violation of Section 4 of the Nagaland Village Tribal Council Act 1978, amended up to 2022. Lordship, just a short day was given, and I was given the privilege to serve dusty service to the respondents, and today they have come. Nevertheless, Lordship, today is for consideration of interim order. Just if my lord will kindly peruse the Tribal Council Act, I have already placed in the
Yes.
yes.
Lordship will kindly come to section 4. My grievances is against this section 4. That has been absolutely violated. Allow me to read out, Lordship. A village council shall consist of members chosen by villagers in accordance with the prevailing customary practices and usages, the same being approved by the state government, provided that hereditary village chiefs, this is very relevant, Lordship, hereditary village chiefs, GBs, and ANGs shall be ex officio members of such council and shall have voting right. This is very clear, Lordship. Now what has happened is the respondent, the private respondent number 5, who is here, the first petitioner is is also one of the hereditary chief, the petitioner number 1 presently. And he has approached this honorable court because the respondent number 5, in order to deny the village council membership to the clans as per the customary law. There are clans, there are 8 clans at Litsami village. In order to deny village council membership to some clients, pick and choose clients, the respondent number 5 included 3 village chiefs, 3 village chiefs and 1 chocho, that is herald, in the village council itself, though they are ex officio members and they have a voting right. In spite of it, this pertains to semi-customary law where the village chief, that is hereditary, and in the village there are 3 GPs. We call village chiefs, and in our Simi dialect it is called Agakau in Simi dialect. So the petitioner is Agakau, number 1 is Agakau, and his name also was without his permission or knowledge, his name was also included in the 9 members, village council members. So they have included, Lordship will kindly come to page 27D. The respondent number 5 and 6, especially both are Agakaus, both are village chiefs, that is called GBs, Gaon Baras. Lordship, allow me to read out. We, the Litsami Village Council, had a general public meeting on 8/4/2026 to change the village council members, and during the emergency general session, the following members has been elected as listed. Name and signature of the newly elected council members. Tokhevi Sema, VCM. So this is the head chief who is an ex officio and they have a voting right. Tokhevi Sema VCM, he is the respondent number 5. He is the head GB. Amongst the Agakau, in Sema dialect, it is called Agakato. So he is the village head GB and his name was included at serial number 1 as VCM. They can never, in violation of section 4, they can never become a VCM since they are the village chiefs. Now 6, Hekuto Yeptho, he is also Agakau. My lord has got it. Then Ahoto Simi, Chocho, VCM. This Chocho is also selected by the village chiefs, and they are the heralds of the GBs. They are the heralds, spokesperson like of the village chiefs, Lordship. So this one, then there is Kento Sema VCM. This one, we have no issue because this person at serial number 4 is selected by the serial number 4 is selected by their clans. That's why we have not implemented the serial number 4. Serial number 5, Shivito VCM. He is also selected by the clans. So this is also not implemented. Then this is Keto V Sema VCM, serial number 6. He was also not selected by the clans. He was not selected by the clans, but was inducted by the respondent number 5 and 6 GBs. Then 8, Kivito Sema VCM. This also, they are all separate clans. This also, Kivito also was not selected by the clans because as per the section 4, the clans as per customary law separate clans select their own, choose their own member to represent their clans as the VCM in the village. So this serial number 6 is respondent number 9. Serial number 7 is respondent number 8. Then 8 is Samuel Sema VCM. This is also selected by the clans, their own clans. That's why we have not implemented these 3. Out of 9, we have not implemented. Then at serial number 9 is Kahoto GB. There is no signature. And he is now the petitioner number 1. Akakao, village chief. He is the petitioner number 1 because neither as per law, they ought not be in the village council members. 1, 2, serial number 5, 6, 7, and 9. They are under section 4. They cannot be the village council members because they are the village chiefs and they are ex officio and they have a voting right. So these 4 were inducted by the respondent number 5 and 6 by themselves. And this, now the petitioner at serial number 9, who was also inducted, he is the petitioner number 1. Now my lord will kindly come to page 29 annexure E. This is the representation submitted to the SDO Civil Suruhuto, Nagaland. Suruhuto is a subdivision, and this is the respondent petitioner number 1, Akakato. He has submitted this representation against the induction of his name as well as 3 others, those who are ex officio members, the chiefs. So this is, allow me to read out, Lordship. To the SDO Civil Suruhuto, Nagaland.
Okay.
Lordship.
You are for respondent number?
I'm for private respondent 5 to 9. And my lord,
5 to 9.
I'm appearing on behalf of Miss Esther Aye, who is the leading counsel in this case.
Miss?
Miss Esther Aye. And we have not filed our Vaklatama also. I'm only giving my first appearance. So, my lord, I pray for some time to object to the interim prayer because this is a very complex issue which involves all the clan.
File your Kalatnama.
Yes, I've not filed. This is my first appearance, my lord.
Lordship,
And the government.
here I have prayed before this honorable court on 14 that this is very emergency because this 4 person were under section 4 of the Nagaland Village Council Act. They are ex officios and they are the village chiefs. Now their name has been inducted in the VCM in order to deny other clans their representative. And why should the petitioner number 1 approach this honorable court when his name is also inducted as the VCM? So here they submitting, they have appeared, yes, we have served to them on 18th. Now today they could have filed their Vakalatnama, but here the question today is before this honorable court. Only my humble submission is it is the obligation of this honorable court that it was given 1 week only because due to failure of justice in violation of section 4. And now I'm just asking for stay of the Lordship. 6 villages has been approved under Zinheboto district.
No, that's all right, but madam, is it not necessary to afford him an opportunity to obtain instruction and also to file his Ukalatnama here? He
Lordship,
has only instruction to appear today. He has not filed his Ukalatnama till now. So would it be proper to pass any order today?
Lordship,
Let us fix a very short date. Let
in the
him come with
meantime,
instruction.
Lordship, the selection of those 9 persons, the government has approved, and that's why I'm just challenging only just Lordship, to satisfy my Lordship. Here are the resolution has also been passed by the whole village against this selection, Lordship. That is, it will come later on, but page 37, F1. The signatories are at page 38. This is without calling general meeting. And my lord, as the petitioner number 1, my lord, can you even see that I have not even assigned my signature in the induction of me at serial number 9, Lordship. And this is the one of the chief coming before this honorable court seeking justice in favor of other clans who has been denied their representation in the village council member that is prevalent in the state of Nagaland under the customary law, Lordship. Now, resolution is also there by the villages here, page 37. This was passed on 26/7/2026. In spite of this, this form was filled up and sent to the respondent number 4. Respondent number 4, who is the Suruhuto, civil SDO Suruhuto. He, without informing the others, sent it to the deputy commissioner Zinheboto. That is the procedure. After acceptance by the civil SDO Suruhuto subdivision, the respondent number 4, who is the respondent number 4, he will send the form to the deputy commissioner, respondent number 3 of the Zinheboto district. Now, then deputy commissioner will send the form to the commissioner's office here at Kohima. Then the commissioner office approves it, and the village council members becomes legal. Now, Lordship will I will just avoid others, but my only humble submission is annexure F, page 33. Just I'm trying to impress my Lordship, because this is very serious matter. Annexure F, page 33. This is approval made by the Office of the Commissioner Kohima. Approval already made without the knowledge of the petitioners. Now, the approval is 35, page 35. Page 35 is one is SDO Civil Suruhuto subdivision. One is Sapotimi, already approved. We have no issue with this, Lordship. 2 is Tichipami village. All these are villages, Lordship. Sapotimi has 18, Tichipami has 15 members. We have no issue here. Then 3 is Jekuto village. Then number 4 is Kuniho village. Then 5 is Koleboto village. And I'm pertaining to only 6. Only this. I'm just praying for stay of this only 6 while the case is pending. Only the 6, serial number 6. And in my prayer also, it's only regarding serial number 6 only, Lordship. I have no other 5 other villages. It will go on as it is because they are legally selected. However, this Litami, and I have placed before this honorable court that 4 village chiefs who are under section 4, who are the ex officio with voting rights. They have inducted themselves as the VCM. This can never be customarily or legally lodged. So this is my humble submission. What I pray before this honorable court is that in the meantime, the government has already issued a notification to select the chairman out of the village councils. The village councils will select a village council chairman. So that is under process and we are at stake, Lordship. And basing upon this, me, especially the petitioner number 1, who is the village chief, is approaching this honorable court. I have been inducted at serial number 9, but I cannot go along with this because this is illegal. That's why I am approaching this honorable court as the petitioner number 1.
No, what legal right of yours is violated here?
Lordship,
What right is violated here?
what
If you have been inducted in the selection list,
my right, I am the village chief. So under section
your
4.
name is there.
Yes, Yes.
How your right is violated then?
it's not about violation. I don't want it. Here is a peculiar circumstances where I have been, without my knowledge, I have been inducted. But we are the village chief and we should not be in the village council. This is the first kind of its stance. Because village chiefs are ex officio under section 4. And they cannot be inducted as village council members. Village council members are inducted as per clan selection. I am Jimomi. One is just an example. I am Jimomi in one village. Jimomi, Asumi, Yeptomi, Ayemi, Achumi. This kind of in Simi customary law. All these clans are settled in one village. So as per section 4, where, my lord, it is very clear that section 4 is very clear, Lordship.
No, that's all right. You have shown me.
Lordship.
Anyway, you work for the respondent number 1 to 4. I am not better. Is that respondents are there?
It's more ancient. More ancient.
Moa Imsen.
Yes.
He is absent today.
Yes, he is, in fact, has submitted a leave of absence of your lordship.
Okay.
It's just simple for then till the next returnable that because Lordship, we have already fixed it for interim order today, and Lordship, if this interim is not, if this Litsami village is not suspended, now the village council chairman is going to be elected and it will be forwarded to the government.
When election will be held?
Yes, Lordship.
When?
I have been informed that they, again, the respondent number 5 and 6, they themselves have elected a chairman, that is respondent number 9. But government has not approved it. It is under process. So such kind of things are going on. This is all over Nagaland, Lordship.
No, that's all right. Let it be on Thursday.
On Thursday.
Let him obtain instruction and also to file his Ukalot number. And in the meantime, Mr. Mao Imsen may also appear. Or
He can appear, Your Lordship, because his leave of office is only up to tomorrow.
tomorrow.
Yes, on Thursday he can appear.
Thursday.
Yes.
Okay. Okay. Heard Madam Jimomi, learned counsel for the petitioner, and Mr. Your name, please.
I am Pakin Richabu, my lord.
Learned counsel for the private respondent number 529. 529. The learned counsel for the private respondent number 529 submits that he has the instruction to appear in this matter, but he has not yet filed his power, and he prays for listening the matter on Thursday.
Yes, Lordship.
Possible at least 1 week time because there are 5, 6 respondents and it's very difficult to reach out to them to obtain your signature. So maybe next Monday.
Lordship, then in that matter, I just humbly pray before this honorable court to just suspend till next listing. Suspend the.
No, madam, you see, today the government side is also absent.
Uh, my humble submission before the Honorable Court is that this interim order, as basing upon the fact
No, that's all right,
of
but
the-
without hearing the other side, it would not be proper to pass any interim order.
then let it be on Thursday.
Thursday,
Thursday, Lordship.
you obtain
They cannot-
inspection and file your color number. Resolution the matter on Thursday. In the meantime, Mr. Sunsul, Learned Counsel for the private respondent number 529 shall obtain necessary instruction and also shall file his power. Thursday. Interim period of the petitioner will be considered on Thursday.
Lordship. Obliged, Lordship.
For admission, item number 3.
My please, Lordship.
Yes.
Your Lordship, this petition has been filed seeking compensation under the Pradhan Mantri Garib Kalyan package. On the last occasion, the union has submitted that the petitioner is eligible and the
Yeah,
amount. Yes.
They asked for 8 weeks time.
Yes.
To manage the fund.
Yes.
Who is for the respondents then?
On 27/7, Your Lordship, we have the petitioner has received. His account has been accredited with the amount. Your
Oh, you have received the amount?
Yes, Your Lord.
So we can close the matter?
Yes.
Okay. Third, Mr. Your name, please?
Zatkun.
Learned Counsel for the petitioner, Mr. Pote for respondent number?
It's number 8.
Respondent number 8. And you?
Maslezo, on behalf of Younger Party, Learned CGC.
Learned CGC. And Madam, you are also partake?
I'm for the state. Lordship.
Miss Inaholi. Learned Counsel for the Learned Counsel for the state respondent. Learned Counsel for the petitioner apprised this court that the petitioner herein has received a compensation amount. And as such, the pair made in this petition has already been satisfied with, and as such, the matter may be closed. Accordingly, taking note of the submission of Learned Counsel for the petitioner and also after hearing Learned Counsel for the respondents, this petition stands closed.
Much obliged, Your Lordship.
Item number 8.
May I please, Lordship?
Yes.
Lordship, here the petitioner prayer for non-payment of salary has already been complied by the state respondents. Therefore, it is prayed that the petition may be disposed of.
Okay. Heard, Mr.
Hissing
Learned Counsel for the petitioner and Ms. Inaholi, Learned Counsel for the state respondent.
Yes, all the state respond.
State respondents. Learned Counsel for the petitioner submits that the pair of the petitioner has been complied with by the respondent authorities, and as such, this petition may be closed. Accordingly, taking note of the submission of Learned Counsel for both the parties, this petition stands closed. Okay.
9 similar.
Eight
Similar
and
order
nine.
maybe.
9 also same.
Lordship.
Same order in 9. Okay.
Much obliged.
Much obliged.
Item number 11.
Lordship, I'm representing the state respondent 1, 2, and 5. I have already filed my affidavit, Your Lordship. Respondent number 4. Respondent number 4, who are the Rehabilitation Council of India. They have appeared through BC. They have sought time on the earlier occasion to file their counter affidavit. I think they are yet to file, if I'm not wrong.
Lordship.
Okay. But no one is appearing on their behalf also.
Yes, yes. However, on the previous occasion, they have appeared through VC and they sought time to file their counter balance.
So can we hear this petition without the affidavit of respondent number 4?
Your Lordship, because it is the guidelines. It is their guidelines that we are following, Your Lordship.
Okay. So we can proceed to hear the matter then.
Your Lordship, I think it's better that if they can file their counter matter. Because we are following their guidelines. That is
But if no one is appearing, then
yes, Your Lordship.
yes. Art Miss,
Raise.
learned counsel for the petitioner, Mr. You,
P. Mere, Your Lordship.
for respondent number,
Respondent number 3.
respondent number 3, and Mr. Angami for
Respondent number 1, 2, and 5. Madam.
1, 2, and 5. The learned counsel for the respondent number 1, 2, and 5 has pointed it out that the respondent number 4, the Rehabilitation Council of India,
Correct.
has not yet filed their counter affidavit. And in order to adjudicate the issue raised in this petition, filing of counter affidavit by the respondent number 4 is necessary. But the respondent number 4 remain unrepresented today. Accordingly, it is provided that registrar shall raise the matter after a week. In the event of failing to file the counter affidavit by the respondent number 4, appropriate order shall follow.
Right.
For hearing, item number 29.
May I please, Your Lordship?
Yes.
Lordship, the petitioner counsel is taking up a matter at the court tree. So if you kindly take up the matter after break.
After break.
Yes, Your Lordship.
Okay, at 12 o'clock.
Yes, Your Lordship.
Is there any other one? No.
One. 2 weeks until today.
Yes, Your Lordship.
Yes.
Your Lordship, here the petitioner's opportunities honorable court for challenging the appointment order of the respondent number 5, Lordship. Lordship, here the petitioner have made an application for appointment on background about the vacant post under the establishment of Government High School Sangbubuka, which is an annexure 1. That is a page 12, Lordship. I may be allowed to read, Lordship.
Page number 4.
Annexure 1, page number 12, Lordship. Annexure 1, that is it, page number 12, 1, 2, Lordship.
Yes.
Yes, Lordship, I may be allowed to read. It is learned from a proper channel that the post of sweeper at Government High School, Sangbu, so is lying vacant and against Shiri so as a major affected landowner. I take this opportunity to apply myself for the appointment of the said post. Now, Lordship, in support of his contention, the landowner had also recommended for the appointment for the said post. The landowner where the Government High School was established. Now, Lordship, here, from a reliable source, it was learned that that is in page 17 clause 8. That is the type copy, Lordship, for more clarity. Page 17 clause 8.
Yes.
Yes, it was learned from a reliable source that the respondent number 5 was appointed, Lordship. Now, Lordship, the petitioner, the affected landowner had also made a representation that is at annexure 6, page 18. Next page, Lordship. Yes, Lordship.
Yes.
The affected landowner has also made a representation to consider the case of the petitioner. Now, my Lordship, we kindly come to page 22, that is it, annexure 7. Page 22, Lordship, annexure 7. Now, Lordship, after the representation has been submitted, the Deputy Secretary to the Government of Nagaland had also made an intimation letter to the Principal Director. We are at serial number 2, Lordship. A copy of the application and documents of Sherisin so based on which her candidature was approved for appointment to the post of MTS Government High School Sanglo. Now, Lordship, after a gap of more than a month, the Principal Director had made a for verification of land ownership, that is at page 22, Lordship, to the Deputy Commissioner.
Yes.
However, no action has been made. Now, Your Honor, may kindly come to page 24.
No, whether verification report was submitted.
No, Lordship, thereafter, no action has been made, Lordship. Now, Lordship, may kindly come to page 24, clause E. That is the.
Yes.
This was the notification issued by the Government of Nagaland, Land Revenue Department. Now, come to kindly para 3 clause C. Para 3 clause C.
Yes. Yes.
It is also clarified that it is not the policy of the government to provide employment to the landowner on privilege deed. The employment of landowner is permitted by a verifiable and valid agreement. It is limited to the first appointment as landowner on the government service and does not entitle as descendant for further employment on the retirement from service. After the appointed landowner retires or vacates the post, the vacancy will be filled up through open advertisement in consonance with the existing policy, giving equal opportunity to all the applicants. However, my lord, the appointment which was made against the respondent to 5, Lordship, he was neither the landowner nor the affected landowner. In the meantime, Lordship, as I already stated in my para number 16, Lordship. Lordship.
Then the petition, I mean, paragraph 16, that is at page 9 now. That the petitioner have no other remedy if this honorable court do not stay the appointment of respondent doing so, which was appointed illegally without following the public employment policy without advertisement. Now, my lord, however, without, despite of the clear office memorandum, the public employment policy has not been, moreover, the applicant was not given the opportunity. So the petitioner is challenging this instant appointment option.
Who is for respondent number 5? You.
Okay.
Okay.
Submission to my.
Okay, let him complete.
Okay.
No, yes, you complete your.
Yes. Lordship, in regard to my submission, I would also like to place one decision which was passed by this honorable court lordship. Lordship, may kindly come to para number 25, Lordship. Relevant parties, para 25, 26, and 27, Lordship.
Paragraph number 20.
25, 26, and 27, Lordship. That is the relevant portion. I may be allowed to read option.
Yes.
This portion. Here the respondent number 7 was appointed to a public post, and as such it is the mandate of law that the respondent authorities have to abide by the mandate of Article 14 and 16 of the Constitution of India, merely on the basis of an approval being given by the government, which is not supported by any selection proceeding, maintained with continuous record. Such appointment would be in violation to Article 14 and Article 16 of the Constitution of India. Further, there's no reason assigned why the respondent number 7 was preferred for among the 7 applicants. Accordingly, it is therefore the opinion of the board that the opinion impugn order to the swing so reverse in the friends as it violates the mandate of Article 14 and Article 16 of the Constitution. 27. Consequently, this board therefore dispose of the petition with the following observation and deduction. Number 1, the impugn order to the swing so by which the respondent number swing so was appointed as a MTS in the establishment of respondent number 6 is set aside in quash. The respondent authority should be elected to reveal the said applicant was only by creating on the first selection proceeding to spread distinct policy. The claim of the petitioner for appointment on land ownership basis shall be subject to scrutiny in terms of the notification dated so and as modification or amended to the said notification. Now, Lordship, I may be allowed to place one more, which has passed by this honorable court. That is in WBC 5/4/2018, which was passed on 2/3/2020. Relevant para is a Lordship, at page 13 Lordship, para 12, 13, and 14 Lordship. Page 13, para 12, 13, and 14 Lordship.
Okay.
Perfect. That is my submission.
Yes, for the state respondent.
Yes, I'm for the state respondent.
Yes.
May I please, Your Lordship?
Yes.
My lord, Your Lordship, may I kindly see my affidavit in opposition filed on behalf of respondent number 2 and 3.
Yes.
Para 4, my lord. My lord,
Yes.
can you allow me to read this paragraph? But with regard to the statements made in Bara 2, 13, 12, 13, 14, 15, 16 of this petition, the answering deponent vehemently denied. It is pertinent to mention herein that though the petitioner has applied for appointment on land ownership ground, her case could not be considered because she is not a real landowner. The petitioner is claiming her rights only basing on the recommendation or no objection certificate given by the landowner, which is not acceptable in the eye of the law and does not confer any legal rights. It may also be noted that respondent number, it should be read as respondent number 5. Typing mistake, it's written respondent number 6, it should be 5. Was appointed not on the ground of land ownership, and her appointment was made after following due procedure and approval from the state government by White Order number 26 for 2023. Furthermore, it is humbly submitted that the department had received the representation dated 15/4/2024 from Sri Animo Sitri, who claimed to be the affected landowner of GHS Sumro and challenging the appointment of private respondent number 5, Srimati L. Nyangpeni Mule, MTS GHS Sumro in the instant writ petition. Accordingly, the representation was duly forwarded before the government by white letter dated 13/5/2024. Thereafter, by letter dated 24/6/2024, the government conveyed the deponent to conduct verification through the concerned district administration and the DO Woka. In pursuance of letter dated 24/6/2024, the answering deponent had requested the Deputy Commissioner Woka by letter dated 23/7/2024, 072/2024, and 015/2025 to conduct verification of the land ownership pertaining to the GHS Sumro Woka and submit the report, the finding thereon. Subsequently, in response to the deponent letters, the Deputy Commissioner Woka by letter dated 6/6/2025 had forwarded the verification report submitted by the ADC signees after examinations of the reports and relevant documents enclosed in the reports, wherein in the para 1 of the meeting minutes dated 28/2/2025 clearly mentioned that Sri Chimomo Mode is the landowner of the land where the GHS Chongro is situated. The land was donated free of cost and has not availed any contractual work nor taken any monetary compensation for the said land. His daughter, Srimati Z. Monchumi Mule, who was appointed on 8/2/2024 against the vacancy caused by the retirement of Sri J. Nepimo, is the only one who has availed employment from the family on the basis of land ownership. It was also clear that there is no objection from anyone against Srimati Z. Monchumi Mule availing the said post. In Para 2, Sri Animo Sitri is the landowner of the land surrounding the school, including the approach road. He had applied for the post of Sigur for his daughter-in-law Srimati Tangpeni Ism in 2019 against the vacancy caused by Srimati Nochamoni. However, the resultant vacancy was filled by Srimati L. Nyanbeni Mule in the year 2023. Hence, objection was raised by Sri Animo Sitri as, according to him, Sri Mati L. Nyanbeni Mule was neither a landowner nor owner of land surrounding the school. As such, the verification report categorically records that Srimati Singh Chimo Mule is the genuine landowner of the land on which the GHS Bureau is situated. The landowner has already availed employment by virtue of appointment of landowner's daughter Srimati Z. Monchumi Mule by appointment order dated 08/2024. It may be further noted that The petitioner herein is the daughter-in-law of Amimo Sitri, not a real landowner, and her claim for appointment on land ownership basis at GSS Sungro is misconceived and wholly untenable. It is an established fact that petitioner is not the landowner on which the GHS Sungro is situated, but rather the landowner of the land surrounding the school, including the approach road. Your Lordship, may kindly see the verification report, my lord. Page 19, my lord. Page 19, my lord.
Yes.
Meeting minutes.
Mm.
Meeting minutes held on 28 February 2025 regarding verification of land ownership at GHS Sungro. A meeting was convened on 28 February 2025 at 1 p.m. at the office of the Additional Deputy Commissioner, Sanis, to discuss on the issue pertaining to the land ownership of GSS Sungro. Woka meeting attendance enclosed. The following points were discussed and highlighted as below. Number 1. Sri C. Chimomo Mule is the landowner of the land where the GHS Sungro is situated. The land was donated free of cost, and he has not availed any contractual work, not taken any monetary compensation for the said land. His daughter Srimati Monchumi Mule, who was appointed on 8/2/2024 against the vacancy caused by the retirement of Sri J. Nirpemo, is the only one who has availed of employment from the family on the basis on land ownership. It was also clear that there is no objection from any against Sri Z. Monchumi Mule availing the said post. Paratu. Sri Animo Setri is the landowner of the land surrounding the school, including the approach road. He had applied for the post of sweeper for his daughter-in-law Srimati Tungpeni in 2019 against the vacancy caused by the retirement of Srimati Nocha Moni. However, the resultant vacancy was filled by the Srimati L. Nyanpeni Mole in the year 2023. Hence, objection was raised by the Sri Animo Setri as according to him, Srimati L. Nyanpeni Mole was neither a landowner nor owner of the land surrounding the school. My lord, here the petitioner is approaching this court only on the recommendation given by the land that the landowner mentioned in para 2, that is the Sri Animo Setri. The land here, the Animo Setri is the landowner of the land which is surrounding the school, madam, not the very spot where the present school is established. So, basing on the recommendation given by the landowner, because the petitioner is the daughter-in-law of this landowner. So, basing on the recommendation given by the landowner, the petitioner has no right to approach this for appointment. That is the case now. So, the petitioner has failed to establish his case, and on this ground, the petition is liable to be dismissed.
She is the petitioner, is the daughter-in-law of Animo Setri.
Yes. And Animo Setri is the landowner of the land surrounding the school, not the building, where the building was established.
Okay.
The main building established in the land of C. Chimomo Mule. The name reflect in Bara 1.
And respondent number 5?
She is not the landowner.
No, here the respondent number 5.
Yeah.
She is?
Respondent number 5, she was appointed against the vacancy created by Srimati Nochamoni.
No, that's all right. On what basis he was appointed?
She was not appointed on land ownership basis, ma'am.
Not on land ownership
Yes,
basis.
she is not the landowner. It's admitted that she is not the landowner. Against the vacancy created by Nochamoni, the respondent number 5 has applied.
Whether any advertisement was published?
No, my lord.
Then on what basis you have appointed her?
My lord, the petitioner has submitted, the respondent 5 has submitted the representation, and her representation was considered by the department and it was forwarded to the state government.
No,
And
that's
the-
all right. Is it the procedure for appointment of a grade 3, grade 4 post? Do you have any notification how the appointment of this grade 3 and grade 4 posts are to be made?
My lord, there is one screening committee should be established in the department.
Whether such a screening committee was constituted here?
That one I have to assume that
No, merely because someone has filed one representation that I may be appointed against a vacant post arising out of retirement of so and so, so and so. Can you appoint any person in that way?
my lord, at that point of time, there was only one applicant and it was.
Maybe, but are you not under any obligation to make any advertisement?
Yes.
So
In this case,
there was no advertisement for the post.
Yes, no advertisement was. It is admitted fact.
Hmm.
Through the department.
And she is also not line owner.
Yes. And the petitioner has also, she has also no right to claim on land ownership basis, just basing on the recommendation given by the landowner.
Maybe. But her right is violated. As because it was not advertised. Had it been advertised, then she could have applied for the same. That opportunity is denied to her. Hmm. Okay. Respondent number 5.
May I please, your lordship?
Yes.
Lordship, one grade 4 post became vacant after the retirement of one Jamnu Lee under the establishment of Government High School Wokha. So I applied for the said post and my appointment was made after following the due procedure.
Due procedure means?
Government has approved my appointment, lordship, and from the state government. And being the indigenous inhabitant of Wokha, I was appointed by the appointing authority. My appointment approval order is annexed in my affidavit, page number 9 to 10, annexure A, lordship. So, lordship may kindly appreciate that memorandum dated 27/9/2003, which the petitioner have annexed in their petition is a mere declaration by the landowner of Government High School, Songro.
Maybe, but whether you have faced any interview?
No, lordship.
No. Whether any advertisement was published?
No, lordship. But by indigenous inhabitant of Wokha, I have applied for the state post, lordship. And the petitioner, in their affidavit in reply, they have clearly stated that they are not the landowner of the establishment of Government High School, lordship.
There is one rule perhaps regarding appointment of grade 3, grade 4 post. One notification may be there.
Lordship may also kindly appreciate that that whether the petitioner is the landowner or not, the documents on record clearly shows that the petitioner claim has already availed the appointment on the basis of land ownership, which I've annexed in my affidavit in opposition, page number 4, paragraph 5. Lordship, page number 16, annexure T. Therefore, the petitioner has not made out any case, Lordship.
Page number?
Page number 16, Annexure D. So whether they are the landowner or not, they have already availed the appointment lordship on the basis of land ownership, their clan. Lordship may also kindly appreciate that it is a settled principle of law that if the person claiming relief is not eligible as per the requirement, then he cannot say to be an aggrieved person.
No,
Therefore, there's
he
no
may
local
not be
standard.
landowner, but there is one notification of the state government as to how the appointment to the post of grade 3 and grade 4 can be made. As per that notification, do you have that notification? No. So in case of public employment, there must be advertisement.
Yes, yes, my lord, there is there is office
One
memorandum.
office memorandum.
Yes,
Where is that
but
memorandum?
that office memorandum is not here, ma'am. But my lord, here, kindly allow me to submit one submission in regard to appointment of respondent number 5. Your lordship may kindly see the appointment of respondent number 5.
Page number?
Page number 12 of affidavit in opposition filed by the respondent number 5. In the writ petition of the your lordship, may kindly see page number 17A. Writ petition. Page number 17A.
Yes.
Para 2, madam. The appointment shall be on probation for 2 years. On completion of the probation period, she shall be considered for service confirmation, subject to fulfillment of condition prescribed in the service rule in force. My lord, the petitioner appointment is on probation.
Maybe.
Not the direct
maybe.
direct appointment. Direct regular post, my lord.
Where is that OM?
OM, it's the OM is not with me, my lord, now.
Can you produce it tomorrow?
Yes, I can.
Should I may be allowed to make a short submission?
Yeah.
Lordship, with regard to the, as the learned counsel for the state respondent has mentioned that the appointment shall be on probation for 2 years. However, my lord, there's no such notification that it shall be appointed on probation for 2 to 3 months. Now coming to the affidavit in opposition filed by the state respondent at para number 5, that is at page 5. They have also accepted they have also not denied the fact that after the appointed landowner retires or vacate the post, the vacancy will be filling up through open advertisement. They have not also denied the same, which is it para 5 of the affidavit in opposition filed by the state respondent. That is it, page 5. That is it, paragraph 5. Yes. The state respondent had also not denied that the employment should be open through open advertisement, lordship, which have specifically mentioned in line number 9 of the paragraph.
Paragraph number 5.
Paragraph 10, lordship. The employment of landowner. Paragraph 5.
Yes.
Yes. I may be allowed to read, lordship.
Yes.
That the answering deponent humbly begs to state that the government has framed a policy for regulating appointment of quid pro quo on land ownership basis. In this regard, notification number so dated so, the Department of Land Revenue has issued a specific guideline in procedure to be uttered while making an appointment to quid pro quo in the land ownership basis. clause 3C of the notification category landowner, it is not the policy of the government to provide impairment to the landowner in perpetuity. The impairment of landowner, if permitted by invalid agreement, is limited to the person first appointment as landowner in the government service and does not entitle his descendant for further impairment on his retirement from service. After the appointed landowner retires or vacate the post, the vacancy will be filled up through open advertisement, which means the state respondent has also not denied the same motion that it should be a through open advertisement. Now, my lord, with regard to the submission made by the private respondent 5, so far as the appointment of one in Zambini Shetri, that is at page 16 of the affidavit in opposition filed by respondent number 5. My lord, your annexure D, that is at page 16, affidavit in opposition filed by the private respondent 5.
Yes.
Yes. Now the private respondent has stated that on the basis of land ownership, this Nzambeni Shitri had been appointed. However, my lord, as per the appointment, there is no such mention that it was appointed on the basis of land ownership. Now, lordship may kindly come to number 2. The appointment is made against the existing vacancy. She receives so with effect from the appointment is for period of 6 months. It is only for period of 6 months. Now, my lord, here, even in my reply, I mentioned in paragraph number 2. Paragraph number 2, lordship, of my affidavit reply to the respondent number 5, lordship. My lord, the person who has been annexed by the respondent number 5, it is nowhere connected with the present petitioner, lordship. Lordship may kindly come to paragraph number 2. Lordship, I may be allowed to read. That the statement made in paragraph number 5 located of the affidavit in opposition filed by the respondent number 5. The answering deponent humbly states that during the establishment of government high school, a huge portion of land had been acquired by the state respondent for improvement of approach road. In fact, what solely belongs to Sheri Swing, who is the father-in-law of the petitioner, with an assurance that any sort of implement contractual work would be provided to the affected landowner. However, no such opportunities have been reviewed till date. As such, the petitioner had made an application to appoint on the basis of affected land ownership, which is annexure 1 of my petition. Now, lordship, that in the affidavit in opposition filed by the respondent number 5, it states that one Sharmati Swinso from the petitioner's clan had reviewed the appointment on the basis of land ownership in paragraph 5 of his baseless without any documentary as that the affected land does not belong to the Shetri clan, lordship.
Okay. Okay, you produce a memorandum of the government now holding the field. Tomorrow we'll take up the matter again.
Yes.
Heard, Mr.
If she didn't.
Learned counsel for the petitioner, Mr. Learned counsel for the your government advocate.
Yes, senior.
For the senior government advocate for the respondent number 1 to 4.
2 and 3.
1, 2, 3, and 4. And madam, for respondent number 5. Third in part, list the matter tomorrow for further consideration.
Much
obliged.